You're walking down the sidewalk, maybe heading to work or just grabbing a cup of coffee, and then boom, you trip on a cracked sidewalk. You're hurt, maybe you're embarrassed, and you just think it was just an accident. No one's at fault. The truth is, it's not always that simple. I'm Brian O'Connor, New York City and Staten Island personal injury trial lawyer, and today I'm going to break down who's really responsible when the sidewalk sends you to the hospital. Now, the first thing we need to consider is what caused you to fall, and specifically, where on the sidewalk did the accident happen? So when you're involved in a trip and fall on the sidewalk, your instinct is to just get up as quickly as possible to get back on with your day. But if you've been seriously injured, the real important thing is to identify what actually caused you to fall. So it's really important that you take note. Actually look and see where or what caused you to fall. Was it a crack? Was it a hole? Was one sidewalk flag higher than the other? Or was it simply debris that caused you to trip and fall? So that's number one. Number two, you need to figure out, did you fall in front of a private home or was it a commercial property? And the reason why this is so important is because the law is very different as to what you need to prove in order to win your case, depending on who's responsible for the sidewalk. Not only is the law different, but the deadlines to file a claim is only 90 days from the date of your accident if the responsible party is the City of New York. This is why you can't wait until you feel better before you call a lawyer. Don't wait. You could lose your entire claim if you miss the deadline. So let's discuss how you win a sidewalk trip and fall case in one of the 5 boroughs of New York City. The Administrative Code 7210 shifted responsibility for the maintenance of sidewalks from the City of New York to the abutting or adjacent property owner in order to maintain the sidewalk in a reasonably safe condition. Now, the exception to this law is if the abutting property is a 1, 2, or 3 family home that's used exclusively for residential purposes and is at least partially owner occupied. Then, under those conditions, the City of New York is actually responsible to maintain the sidewalk. So, assuming you identified the condition that caused your accident and you determined that it's a single family home where the owner lives there, meaning it's not a rental property or an investment property. Now, we know that this sidewalk is the responsibility of the City of New York. So how do you prove a case against the city? Well, the law requires that you must establish that the City of New York had what's called prior written notice of the specific defect that caused you to be injured. That means that the city had to have notice in writing at least 15 days before the date of your accident. Now, this is an extremely difficult legal requirement to prove. Now, in doing this for more than 30 years, I've certainly been able to establish this on occasion, but you can't always prove that they had notice in writing 15 days before the accident. Now, the law is very different, and I would say much easier if the sidewalk accident occurs in front of a property that is not residential, as we described earlier. Now, these properties are typically commercial properties, apartment buildings, or offices, or other privately owned properties that do not fit into the residential exception. Now, in these cases, you don't need to prove prior written notice against the property owner. In fact, to prove a sidewalk defect case here, you only need to establish that the adjacent or the abutting property owner either caused and created the condition that caused you to fall or had constructive notice of the condition. What that means is that they knew or they should have known about the sidewalk defect. So there's no particular time frame that they need to have known about it by, but just describing it as constructive notice and that they knew or they should have known. So most of these types of cases, all we really need to do is go to like Google Maps or Google Street View, and we take a look at the sidewalk in front of the property. You can not only see the views today, but you can go back years prior. And then you can see from the Google view, the sidewalk was raised last year or the hole was there 2 years ago. That's the easiest way you can establish that the property owner had constructive notice. Of course, you may also prove this in other ways, like neighbors who may have walked the same sidewalk in the months before the accident. Now, I want to discuss an exception in cases where a sidewalk is typically the city's responsibility, in which you must prove prior written notice. But you may be able to prove the private homeowner who uses the property for residential purposes and resides at the property can still be found responsible. This is very important because I don't want you to at some point say, well, I waited too long, I missed the 90-day deadline to file a claim against the city, when the private homeowner could still be found responsible, even though it's a residential property. Now, one of the exceptions is if the private residential homeowner caused and created the sidewalk defect. They could still be held responsible under the law, even if you don't have prior written notice as to the city. An easy example of this we see many times is when the private property owner has attempted to make a repair to the sidewalk, but in fact they actually ended up making it more dangerous than it was before. The other exception on these private residential homes is where the accident occurs in the portion of the sidewalk that crosses the driveway. And this is called the special use exception. And that's because the private homeowner is getting a special use of that portion of the sidewalk above and beyond the use that the general public gets. So essentially the argument is that the sidewalk is cracked or broken because a private homeowner has been making special use of that part of the sidewalk when they drive their vehicles into the driveway and then back out into the roadway over the course of time, thereby causing the sidewalk to crack. And that's the special use exception. So you need to be careful. Even though it's a private residential home, you may still have a case against the private homeowner if you can prove that they caused or created the defect or that they made a special use of the sidewalk. One more danger to be aware of is when it comes to commercial properties, is that even though the sidewalk in front of a commercial property was where your accident happened, and you might think, well, I don't have to worry about the 90-day deadline or prior written notice because it's a commercial property owner. I just need to prove that they knew or they should have known about the defect on the sidewalk. Now the fact is, if it's in front of a commercial property and your accident did not happen on the sidewalk, but it in fact happened on a curb or in a tree well, then it goes back to the city of New York because the city is responsible for curbs and tree wells as well as roadways. Now these are not considered part of the sidewalk. So if it's a tree well or it's a curb, you still need to file a notice of claim with the city of New York within 90 days of your accident. So if you're involved in an accident on a sidewalk, don't wait until you feel better in order to pick up the phone and call a lawyer to see if you have a claim. The time starts to tick from the moment of the accident, and you really need to reach out to a lawyer within the first 90 days. In fact, sooner than that, to provide the lawyer with enough time to investigate and then timely file the claim. Now, if you've got any questions about the sidewalk law, or if you've had an accident on a sidewalk, whether or not the facts of your case constitute a claim, give us a call. I'd be happy to discuss the facts of your case and explain your legal options. We're always here to help.